The first matter to come before the court this morning is State of Ohio versus Daniel Bidding. Both sides will have 15 minutes to argue. The appellant may reserve up to 5 minutes for rebuttal. If you're the appellant and wish to reserve any time for rebuttal, I'm keeping the clock this morning, and I can keep you apprised of the passage of time. We've read the briefs. We're ready to proceed when you are.
Thank you very much, Your Honor. May it please the court, I'm Alan Medvick. I represent the appellant and defendant in this case, Daniel Bidding. I would reserve 5 minutes for rebuttal at this time. Mr. Bidding was convicted of two counts, one of aggravated robbery, and complicity to aggravated robbery, and complicity to robbery at the trial level. On appeal, he has raised 3 assignments of error concerning the insufficiency of the evidence, the verdict against the manifest weight of the evidence, and an assignment of error that the prosecutor committed prejudicial error by repeatedly referring to the BB gun at issue in this case as a firearm during his closing arguments. I would start with the conversations about insufficiency and manifest weight. Specifically, I want to talk about the gun. I think that there has been no evidence presented to demonstrate that the BB gun at issue here was a deadly weapon as required for the offense of complicity to aggravated robbery. This is a BB gun, not a firearm. The case law regarding robberies in this case, and aggravated robbery involving a BB gun, is that of course a BB gun could be a deadly weapon, but that has to be established by the evidence at trial.
Wasn't there evidence, counsel, that there was a warning on the gun that said could cause
There
death?
was a warning. Yes, I'm sorry to cut you off in your question, Your Honor. There was a warning label on the gun which indicated that misuse could cause injury or death. That in and of itself I don't believe constitutes evidence that it was a deadly weapon in this instance. There is no evidence presented as to what would constitute misuse that could lead to death. The case law around this has indicated that where a weapon, and as an example, and I'm sorry, we'll come back, many items can include labels very similar to this, including toy guns, cap guns, that the misuse of those items could cause injury or death. I don't know that, who would be the victim of death what is misuse, who is the potential injured party, are all not contained within that label. There could have been injuries to the self, death to the user himself. What constitutes misuse and what constitutes that concern, I don't think is defined by the label, and there's no evidence presented at the trial level to say that in this instance this constituted misuse or it constituted misuse that would have led to the victim of the offense. Now, I'm in no way saying that BB gun is designed to be brandished across a counter, that is what the purpose of that is, but I'm not saying that this is misuse that would lead to constituting this as a deadly weapon. There's also,
in addition to being generally brandished, it was pointed directly at the clerk's face?
it was pointed at him, but at a distance. There is, and again, evidence that is required to demonstrate that a BB gun could be a deadly weapon is, one of the factors is, what is the propulsion, what is the speed of release of the pellet of the BB? There's no evidence presented of this, how far away. In some of the other cases that were presented by the state, for example, State versus Houston out of the 8th District, probably the most recent case on this, that gun was placed against the victim's head. I think that that's a circumstance that changes this significantly. This was brandished at a distance. The time of release, what the possible outcomes of this injury, my argument would be that would probably have required at least further testimony, if not expert testimony.
Is there testimony in our record that tells us the actual distance or
I don't believe so. I believe it was across a counter at a minimum. I don't have a distance in feet that I recall. There is also statements, although none of this was brought up in the trial record. There are statements out of the 8th District, and there seems to be some conflict about this with the case out of with a line of cases out of the 5th District. The States versus Houston, State versus Hicks out of the 8th District that refer to a BB gun as a potential deadly weapon because it could be used as a bludgeon. That is, the 8th District seems to treat that as a de facto matter, whereas State versus Brown treats that as an evidentiary fact that you would have to be presenting evidence that it was intended to be used as a club, as that kind of weapon, as well as a demonstration of the weight of the gun, as well as that it actually could be used in that manner. There is no evidence in the record. I do admit that the jury had physical access to the gun and may have been able to make that determination, but there's no argument about that. In fact, the sole argument at the trial level was that this was a weapon being used as a gun, and I would point to the prosecutor's repeated reference, mischaracterization of the weapon as a firearm in his closing argument.
That was corrected, wasn't it? By trial counsel and by the court's instructions.
And I'm not, at this point, I'm not trying to talk about that as prejudicial error itself. I'm talking more that the sole characterization by the prosecutor of this weapon was as a gun, and that its intended use was to be as a firearm.
The weapon had, at least when it was taken into evidence, had the CO2 cartridge, did it not?
And that is true.
Any discussion in trial as to whether that was the nature of the weapon at the time it was used in the offense?
In terms of?
Having the CO2 cartridge?
There was evidence that was a CO2 propulsion BB gun, that is, but as there was no discussion as to how that makes the weapon different from other sorts of BB guns, from what that effect would be in its ability to be used as a weapon or a deadly weapon at this point. There's nothing in the record to indicate the significance of that CO2. So at this point, I would conclude that the state failed to present evidence sufficient to sustain a finding that BB gun in this case was a deadly weapon. And therefore, the Rule 29 acquittal regarding complicity to aggravated robbery should have been granted, and it was error not to do so. I would like to speak a little further about the complicity aspect of this regarding both insufficiency and manifest weight. Mr. Bidding was unquestionably not the wielder of the weapon. He was not the principal actor in this case. There is testimony from the perpetrator himself, Mr. Jones, discussing that he did receive a BB gun from Mr. Bidding. It sounds like in the record he received a BB gun that he used prior to any discussions of the theft offense. So for the possession of that weapon to be a knowing aspect of complicity, I think is at issue at best. I think it's unsupported that could be, that the receipt of the BB gun itself could be considered aiding and abetting in this offense, because I think it's clear in the record that he said he received that some 5 weeks or more before, and I think the discussion started after that point. Further, I think that while there was discussion of the robbery, discussion back and forth from Mr. Bidding and Mr. Jones about performing it himself, how to perform it, whether or not to perform it, I think the admonition is not to do so. The evidence supports a conspiracy from which Mr. Bidding, I think, took active steps to withdraw from. And now I think we're faced with, having done so, does that leave a complicity charge? Is that gutter default position?
Well, I'm sorry,
sorry.
counsel. What would those active steps have been?
I believe he tried to talk him into not doing it, and I don't believe that he went. And at the time, I believe he admonished the sole statement that anyone can confirm that he said was a statement of what are you doing. He raised his hands and moved away from Mr. Jones. Now, I think that that's an indication that he wanted no part of that. I know that the state did and probably will characterize that differently.
Well, there was other evidence that he looked outside,
And
almost like a lookout, that he didn't leave, he didn't call 911.
And those are characterizations, those are assumptions that were made. I also believe that the statements of the principal actor, Mr. Jones himself, that he acted on his own are in the record. And regarding this, I think that this is more supportable as a question of against a manifest weight than regarding insufficiency. I will acknowledge that there is evidence in the record. It could be interpreted in light most favorable to the state to sustain an acquittal on the robbery charge here.
And counsel, you just now started to reach into that 5-minute rebuttal time.
Thank you. At this point, I'll reserve and allow the state to talk.
May it please the court, my name is Richard Cassay. I'm representing the state of Ohio in this case. The initial discussion was about the sufficiency of the evidence, and then counsel alluded to a manifest weight argument. Under the circumstances, I think it might be important to describe in very brief fashion what those standards of review mean. Now, when counsel says the evidence was insufficient, what he's saying is that in order to prove an essential element of the crime, the state's evidence, even if admitted to be true, and that's part of the test, the state's evidence is taken to be true, he is saying that with that evidence admitted to be true, that no reasonable jury could find the essential element beyond a reasonable doubt. Now, obviously, the state doesn't think that's true in this particular case, and I'll get into manifest weight shortly. As far as this BB gun is concerned, what is the evidence that it is a deadly weapon? Now, it is not a deadly weapon in the same manner that an actual firearm is, because it's not built to be used as a weapon. But it is capable of being used as a weapon, and is capable of inflicting death. Why do we know that? Under the sufficiency test. We have the label. It says clearly, misuse can cause death or serious injury. We have its use. One of the cases I cited, State versus Houston, makes a distinction in regard to a BB gun. How is that BB gun used? Is it pointed at somebody's foot? Is it pointed at their finger? Is it pointed at their face? Now, this particular gentleman, the minor, Mr. Jones, came into the store and pointed, according to the testimony of the cashier, he pointed it right at his face and threatened to kill him with it. So we have the label.
Wait a minute, was there testimony that he verbally threatened
Yes,
the clerk?
threatened to kill him.
There was, okay, thank you.
And the clerk testified that he thought he could possibly die at that point.
Thank you.
We have the use of this BB gun. Then we have the case law. Several cases indicate that, yes, a BB gun, in the right circumstances, is a deadly weapon. I've cited them in the brief. Lloyd, counsel talked about Lloyd a little bit. That's somewhat important, maybe tangentially, because that case says that a BB gun can also be a deadly weapon in that it can be used as a club or a cudgel. Now, there started to be an issue, I think, as to the physical appearance and composition of this particular gun. The court has it. You're free to look at it and decide for yourself if that thing is swung against somebody's head, is that capable of inflicting death? Now, it's true the state at trial did not argue that principal point that this could be a cudgel or a club, but that's probably not dispositive that the state didn't argue it. If it could be, then the jury could find. But
Or was there testimony about this is the weight of this weapon, it could be used as to bludgeon somebody to death? The record's absent of any such testimony, isn't it?
As I say, the gun is admitted into evidence. The jury saw it, had it, and the court has it too. So you're free to make your own determination of whether or not a jury could reasonably infer that this, if used as a cudgel, could cause death. But here it was used as a gun, pointed at his face with the warning label, and the case law supports the argument that that thing, under those circumstances, is a deadly weapon. Now, going on into the complicity portion of the argument, I understand counsel there to be framing that particular issue under a manifest weight test. Now, the difference between manifest weight and sufficiency is that in sufficiency, as I said, the court has to assume the truth of all the state's evidence adduced on whatever essential element we're talking about. In a manifest weight standard, this court has a discretion, a limited discretion, I would say, to review the evidence and search out conflicts in the evidence such that the court feels that the jury lost its way and created a manifest miscarriage of justice. That doesn't mean that this court becomes a jury, because this court has held on several occasions that there is still a measure of deference paid to the jury's determination because they are the ones who saw the witness face to face and had the actual ability to judge the witness's demeanor. But this court does have the discretion to find that conflicting evidence leads to a manifest miscarriage of justice. Now, I would submit to the court that there is little or none. If there is any conflicting evidence, it's less than an iota, because the minor said that Mr. Bidding, number one, gave him the BB gun, number two, they planned the robbery, number three, they split the money afterwards. Now, if that isn't complicity, I don't know what is. On top of that, according to the cashier, Mr. Bidding came in after Mr. Jones came in, stood there exhibiting no particular sense of alarm while this kid's pointing this BB gun at the cashier's face, and acted as a lookout. And I mean by that, he opened the door and looked outside, then the two of them left and they ran off in the same direction together. So, is that complicity? Aiding and abetting. Did you encourage? Did you counsel? Did you plan? Did you advise? Yes. In this case, there's simply no question that Mr. Bidding aided and abetted Mr. Jones in this robbery. What does that mean as far as the sentence? Again, one who is guilty of complicity is guilty as if he were the principal offender. So if the range of sentences for the principal offender is 1 to 5 years, the complicitor is subject to that same penalty. What else do we have in this case? The mischaracterization of the BB gun as a firearm. For some reason, the prosecutor lost his balance and referred several times to the BB gun as a gun or a firearm. Then, finally, defense counsel says, no, it's not a firearm, it's a BB gun. And then the prosecutor, I think a different one, thankfully, said, you're right, it is not a firearm. It isn't. We'll have to prove to you what it is insofar as proof of a deadly weapon. The trial court correctly instructed the jury on what is a deadly weapon under the facts of this particular case. So the state's position there is the initial error was cured by the agreement of both counsel that, yes, this is not a firearm, and further cured by the trial court's proper instructions.
Now, in addition to the proper instructions, was there any curative comments or instructions by the court at the time these misstatements were being made to the jury?
No, I don't recall any. I don't think there was an objection either, as far as that goes. But they were wrong, there's no doubt. But cured, as I say, and there's no possibility of prejudice here. Unless the court has any questions, well, let me address one more thing. There was a question about the CO2 cartridge. How do we know that was on that gun, or on that BB gun, when the minor pointed it at the cashier's face? Well, we know that because Jones, the minor, when he was shown State Exhibit 3, the BB gun, and he was asked, just a BB gun. He says, if that is the gun that the defendant gave me for the robbery, that's the one I received from him a couple weeks before. So, yes, the evidence allows the inference, the reasonable inference, that the gun as recovered, the BB gun as recovered by the police, was in the same condition that it was when Jones pointed it at the cashier's face. Cartridge attached. Now with that, if there are no further questions, I'll conclude.
So if a nail gun was brought into a store,
Yes,
air compressed
right,
projectile,
yes.
your argument is based on how it is used, the facts, it's a factual issue to
Correct.
determine whether or not it's a deadly weapon, that you do not then need to bring in a ballistics expert or have any testimony about the capabilities of that particular instrument.
I think there were, are you finished with your
Yes.
question? Okay.
I want to make sure you understand the question.
I do. Nail gun that uses some...
Or any air compressor type instrument.
Well, if I have a nail gun, what that means is I can put it against a piece of wood, press a trigger, and a nail goes in. As long as there is some evidence that that particular mechanism can perform that function, drive a nail through a piece of wood, yeah, then that's going to be a deadly weapon because it can go right through your eye if used improperly.
What evidence was there here that this BB gun could perform in that manner?
The label. If misused, this can cause death.
But even that nail gun would have a label.
Well, good, I hope it does. I mean, it should. The label on any particular mechanism or tool which tells you if you misuse this, you can cause death, I think that means something.
I think perhaps what Judge Tidosio may also be touching on is evidence of operability of the BB gun.
Well, it was, the detective said it was loaded with BBs, so if we have a gun, it's loaded with guns, with bullets. I had the CO2 cartridge attached, and I'm looking for some testimony. I don't know that there was a strict operability test.
And there was no objection as it relates to that trial, correct, counsel?
No, I don't think so. So, well, let's analogize that to a gun. State brings in some cheap High Point. It's loaded, it has bullets in it, there's nothing mechanically wrong with it, there's no evidence that there's anything mechanically wrong with this. Now, can that thing expel bullets? Can the jury, more to the point, can the jury infer that the High Point pistol can expel a bullet if you pull the trigger? Well, if it appears in usable form and it's loaded with ammunition, I think the jury could infer that, yes, indeed. Now, what the state does, if possible, and will go ahead and test that thing, just fire a bullet from and say, yeah, there it is. But to answer your question now that I understand it, I don't think there was an operability test performed.
Thank you.
If there's no further questions,
Would you argue that you need operability for a deadly weapon?
I think...
I guess I would say, wouldn't you argue that you don't need operability?
Well,
for
I think
deadly
I kind of indicated that you don't necessarily. Again, this is a factual issue. Operability, if you're talking about a firearm, it has to be operable to be a firearm. So depending on the type and appearance, and is it loaded or is it unloaded, those are all things that go into whether or not the jury could infer that it is operable or not operable. Now, again, if this BB gun can be used as a cudgel, then operability is not an issue.
Sure, but the big difference there is in a firearm, you've got an explosive, combustible,
Yes, you have a...
as opposed to air compressor,
Which, yeah, again,
CO2 cartridge.
you have the CO2 cartridge which was attached. So I'm not an expert on BB guns, but I think what happens when you press the trigger is that allows the compressed air to come out and
At a certain force, which
propel the BB out, yes.
would have been nice for the state to have an expert come in and testify to that in front of this jury, which did not happen in this case.
Well, we can't let the perfect become the enemy of the good. No, it wasn't perfect.
Thank
All
you,
right, thank you.
Counsel.
Thank you.
Counsel, you have 4 minutes and 40 seconds.
Thank you. I'll try to be brief. I think the prosecutor summed it up with his last statement pretty well when he indicated that he was not an expert on BB guns. I am not an expert on BB guns. Prosecutors in this case are not experts on BB guns. Jury and the judge at the trial level are not experts on BB guns. I think as to the operability and the deadly nature of the BB gun at issue here, I think an expert was probably not only nice to have, I think it was probably necessary, or at least some demonstration of both the operability and the manner in which this weapon could have been operated. I think that it is the other thing the prosecutor indicated was that he made a reference to analogizing to a firearm, and I think that that is a dangerous analogy here. I think it starts to turn a BB gun into a de facto deadly weapon under any circumstance, especially it starts to transform a toy into a deadly weapon, and at what point does that stop? In particular, the ability to use a BB gun as a cudgel, and that being an indication that it could be a deadly weapon, regardless of any evidence that it was intended to be used as such, essentially turns anything into a deadly weapon. You could take out the operability, you could take out the fact that it was a BB gun and not a cap gun. The fact that it was a gun, I mean, how far, I'm not trying to push the bounds of reason. I mean, if the man was to point a stick at the clerk and say, I'm going to shoot you, could you then say it's a deadly weapon because it's a club? I think that that is a difficult proposition and a strange argument. I don't think that that is a sound analogy. I think the important part is that it's not a firearm, that is why this is not a per se deadly weapon, and that needed to be proved at trial, and that the prosecutor at the trial level failed to do so. I would address a couple of questions in the record that were presented both to myself and the state. Regarding the distance of the gun, the record indicates, the clerk's testimony indicates that it was about arm's length away. The statements made by Mr. Jones to Mr. Barnett was not that he would be killed, but that I am not playing around. That is not a statement implying death, or that Mr. Jones believed that the weapon could cause death. I think that the other aspect of this is that a BB gun is not intrinsically a firearm. It's not intrinsically a deadly weapon as a matter of law. The question of the clerk's belief, I think there's a subjective test to be proven, an objective test to be established whether this was a deadly weapon, not a subjective test as to whether the clerk himself believed this to be a deadly weapon. Those are some issues I wanted to clarify regarding prior questions of this court. There is no evidence presented regarding my client's participation in the robbery at the time. There is, in fact, the statements seem to indicate, the statements in the record, only from the state's witnesses. Mr. Jones and Mr. Barnett testified solely on behalf of the state. I believe Mr. Jones was testifying as part of a plea agreement to not have this case, to not be tried as an adult in this manner. He pled guilty to it in exchange for testimony here. He had nothing to benefit from misrepresenting this case, or his testimony at that point indicated that he alone had committed the offense. The only statement the clerk made, or the clerk heard from my client, was a statement of "what are you doing?"
And counsel, I need to advise you that you have utilized your entire 15 minutes.
I thank you for your time.
Thank you. Thank you both for your presentations this morning. The court will take the matter under advisement and issue a written decision, which will be mailed to both sides, as well as posted on the Ohio Supreme Court website, which can be also accessed through the 9th District Court of Appeals website.